Okay, we are right at the top of the hour, so we're going to go on and get started. I want to thank everyone for joining us today. I would like to welcome everyone to our Road to HIPAA Compliance webinar series. Today we're going to be talking about managing business associate compliance, which is a critical part of HIPAA compliance. I just want to go over a few things before we get into our discussion today. This session is being recorded, and all attendees will be receiving a link to the recording as well as a copy of the slides. Everyone will also be receiving CCB Continuing Education Credit Certificates following the presentation. All attendees will be muted throughout the session, but we do encourage everyone to ask questions using the Q&A feature, which is located on the WebEx toolbar. I will monitor those throughout the hour, and we will have some time reserved at the end to answer those. Just to give you a little bit of background about who we are, Kirkpatrick Price is a licensed CPA and PCI QSA firm specializing in information security and regulatory compliance audits, providing assurance services to over 400 clients in more than 46 states, Canada, Asia, and Europe. The firm has over 10 years of experience in compliance frameworks such as HIPAA and HITECH, ISO 27001, 27799, and NIST. We do offer both regulatory compliance and information security services. We provide consulting services such as policy and procedure drafting, risk assessment, internal audit plan and development, and readiness audits. And we also provide guidance and audit services on frameworks such as HIPAA, SSA 16, SOC 2, PCI DSS, FISMA, and ISO 27001, 27002. I just want to take a quick moment before I hand it over to Mark to invite you to connect with us. You can subscribe to our blog for regular industry updates, tips, and best practices. We also keep a library of our recorded webinars located on our website. And LinkedIn is another great way to stay in touch with us and be notified of upcoming webinars and other industry news. At this time, I would now like to introduce our speaker, Mark Heinley. Mark is a regulatory compliance specialist with Kirkpatrick Price and a member of the Florida Bar with 9 years of experience in healthcare law, regulatory affairs, and internal compliance in the public and private sectors. His specific experience includes serving in the General Counsel's Office for a state healthcare oversight agency, regulatory affairs for a Medicare, Medicaid, HMO, and complex healthcare litigation. He is also SAM certified in the law of data security and investigations. Welcome, Mark.
Thank you, Sarah, and I'd like to join Sarah in welcoming all of our attendees to our continuing Road to HIPAA Compliance webinar series. As she mentioned, today we'll be talking about managing business associates. Before I begin, I want to give a bit of a disclaimer that we always give. This presentation is provided by Kirkpatrick Price for educational and informational purposes only and does not constitute legal advice. No attorney-client relationship is established by viewing this presentation, and should you need legal advice, we request that you please consult with your own attorney. Now that we have that out of the way, I want to get started. And first, I want to acknowledge something. I know the title is Managing Business Associate Compliance, and so that title might give you the perspective that we're going to be addressing covered entities in this presentation. But I want to assure you, if you're a business associate attending this webinar, that this presentation isn't designed just for the benefit of covered entities. If you are a business associate, I believe this information will give you insight into the issues that covered entities should be dealing with and how that impacts you. And there are decisions to be made both by covered entities and business associates and how they approach some of the requirements within HIPAA. So the requirements are there, but there are different ways to address those requirements. So the goal for today's presentation is to identify the issues that covered entities and business associates have to navigate, and then provide some specific ways to address those issues. Before I give you a summary of what we're going to talk about today, I want to impress upon you the significance of this topic, why it's important that we talk about business associate compliance. One source said that 50% of healthcare breaches are caused by or experienced by business associates. And a covered entity can violate HIPAA because of business associate noncompliance. And we'll talk about that a little bit more later on in the presentation. So the first reason is the frequency of business associate breaches and the impact that that can have from a regulatory perspective on a covered entity. The second reason that this topic is significant is because the OCR has begun phase 2 HIPAA audits. Just a few days ago, they sent out document requests to about a little over 160 covered entities. That's something Patrick Price is engaged in, and those document requests are coming due this week. And so they're starting with covered entities, but there will be a portion of the Phase 2 audits that cover business associates, and that'll happen later on this year. And so in addition to Phase 2 audits, there's also the OCR is planning on having a permanent audit program after Phase 2 is done. So we've got some liability concerns, and we've got regulatory activity in the near future, and then an ongoing sense. A third reason that this topic is important for business associates to consider is my expectation is that covered entities are only going to increase their oversight of business associates. And for some of you that may seem like it's not possible. For others of you that may seem like anything would be better than nothing. But I expect covered entities to continue to increase their oversight of business associates. And so what that means for business associates is the marketplace is going to get more and more competitive. And so the business associates who are able to handle covered entity concerns are going to be the ones that are able to get more business and potentially even stay in business. So even if you're hearing about the Phase 2 audits and the future permanent audit program and you're thinking, yeah, we've heard this before, I'll believe it when I see it. If the regulatory sanction concern doesn't drive any of us to motivation for change, then perhaps the business need and the market forces will bring us to consider the need for business associate compliance. And the fourth reason that this topic is significant is because the nature of healthcare services in our current climate means that if you're a covered entity, someone else is likely fulfilling a critical role for you. One survey that evaluated business associate compliance interviewed the covered entities and asked them to provide the number of business associates they had as of the date of the survey. And that group found that some of the covered entities had as few as 4 business associates, but some of those covered entities had as many as 10,000 business associates. So trying to imagine having 10,000 business associates, and from my perspective at that point, you pretty much qualify as a country more than a covered entity, and you can just start issuing currency and levying taxes. But in all seriousness, there's so many requirements and so many opportunities for risk and liability when your number of business associates is growing. And even at 4, you still have plenty of opportunity for risk and liability. So we've got the concepts of associated liability, the regulatory activity that's ongoing and predicted in the future, market forces, and just a broad scope, the pure number of business associates that are going to be providing services to you as a covered entity. And that's the reason that it's important to talk about managing business associate compliance. So now that we've established why this topic is important, let's go on to our agenda for today's presentation. Our presentation today is going to be broken up into 3 parts. We're going to first talk about business associate agreements, and not just the dry required elements, but also some different approaches to thinking about business associates in the first place. And then our second portion of the presentation today will talk about some challenges and some tools with respect to business associate oversight. And then the final piece of our presentation today before we get to the questions are some common issues that covered entities and business associates need to be aware of. So let's talk about business associate agreements. The privacy rule requires that a covered entity obtain satisfactory assurances from its business associate that the business associate will appropriately safeguard protected health information that it receives or creates on behalf of a covered entity. And that satisfactory assurance must be in writing, whether it's in the form of a contract or another agreement between a covered entity and a business associate. So a business associate stems from a regulatory requirement. But there are also some practical considerations regarding business associate agreements. So if you know that you need them by law, the challenge is knowing who your business associates, if you're a covered entity, the challenge is knowing who your business associates are. And that might seem like an obvious concept, but the volume of business associates that some entities have, as I talked about before, if you're talking about in the hundreds, in the dozens even, or hundreds or potentially even thousands. There are some covered entities that report that service agreements are often signed before their legal department even sees the agreement, or even worse, there are service agreements that are signed between covered entities and business associates, and the legal or compliance team doesn't even know about it. And if that wasn't bad enough, then there are times where there's not even an agreement signed, and services just start being performed before anything is even put in writing, or it's never put in writing. So one of the practical challenges is you have to identify who your business associate is. So as our Lego Macbeth is drawing us to the idea of to business associate or not to be a business associate. There are a couple of ways that covered entities might think about who they need to have a business associate agreement with. And one perspective is the conservative, better safe than sorry approach. That is, just in case a service provider comes in contact with PHI, or in case the service provider is providing some kind of service that doesn't involve PHI in the moment, but just in case that relationship develops and evolves in the future, they're going to have, a covered entity is going to require a service provider to go ahead and sign a business associate agreement now. In fact, one covered entity I read about, they require their landscapers to sign a business associate agreement, just in case the landscapers somehow view or receive PHI. So that's kind of the extreme of the cautious perspective, that just be safe and sign everybody to a business associate agreement. The other perspective on the other end of the spectrum is that only business associates are business associates, and thinking this can't get more obvious. But this perspective says that the monitoring requirements for business associates are significant, the challenges are significant, so a covered entity should only commit to monitoring entities that are actually business associates, and that you don't want to start monitoring your landscapers and your cleaning crews and your exterminators, but just the entities that actually receive or create or transmit PHI on behalf of a covered entity. And the definition of a BA is a person or an entity that creates, receives, maintains, or transmits protected health information for a regulated healthcare function or activity, or performs legal, actuarial, accounting, consulting, data aggregation, management, administrative, accreditation, or financial services for a covered entity that involves the disclosure of PHI. So with that lengthy and verbose definition, here are a couple of questions that we should ask if we're going to take the approach that we only want to sign BA agreements with entities that we believe are actually business associates right at the moment. The first of those questions is, does the vendor actually have access to PHI? So not all services that are provided to a covered entity qualify a service provider as a business associate. For example, a software provider that is only providing software and a license to that software doesn't make that software provider a business associate. But if that software vendor starts receiving access to PHI in order to provide troubleshooting assistance, or if the software provider hosts PHI on a server, then they would actually have access to PHI and they would be considered a business associate. So the first question is to really determine with specificity whether an entity that's providing services to a covered entity actually has access to PHI. And then the second question is to ask what kind of data does a service provider actually receive or transmit or create. So if you had a limited data set which is just facial identifier, where the facial identifiers have been removed, so things like names and social security numbers and addresses or phone numbers, so you're only left with things like pieces of information like dates of service or admission or discharge, ages, city, zip code. If you're dealing with just a limited data set and you get assurance that of controls through a data set agreement, then you don't need to have a business associate agreement. So this might be applied to a smaller subset of organizations. So, for example, researchers or a state hospital association might be the entities that would receive a limited data set and therefore might not be subject to a business associate agreement. So if you're going to take the perspective on only signing business associates to business associate agreements, and you've got these questions of are they actually receiving or viewing or transmitting or creating PHI, and then what elements of PHI are they actually receiving or viewing or transmitting. But that still can be a challenge to determine whether an entity is actually a business associate under the rule. So, you know, you've got examples of business associates that are pretty non-controversial. You've got standards like billing companies, clearinghouses, letter vendors, benefits administrator. But then you have some other service providers that might not be so obvious. So, for example, data centers or online backup companies, cloud service providers. Even if they don't access data, they would store and receive data. Another maybe not so obvious service provider that Kirkpatrick Price comes across are debt collection companies. So we do work for collection agencies that conduct medical collections. And it's not just the covered entities that may not be thinking of service providers as actually business associates. Sometimes the business associates themselves don't always think of themselves as subject to HIPAA. And so one of the challenges in determining who needs a business associate agreement is who's actually a BA. So once you have addressed the question of who is a business associate and what kind of approach are you going to take, whether it's the better safe than sorry approach or limit it to only the entities, the service providers that are actually determined to be business associates with the information that we just talked about, then the next consideration is what information you have to include in a business associate agreement. So there are several of these, so we're going to go through the first 5, and then the next slide will include the remainder of the requirements. And these are specifically listed out in 45 CFR 164.504. So the first item that is required for a business associate agreement is the uses of PHI. You have to establish the permitted and required uses and disclosures of protected health information by the business associate. So this is governed, the first issue you have to address, the first question you have to ask is what kind of services is the vendor providing? And then once you've identified that, then you can establish the permitted and required uses and disclosures of PHI. Within this first item is another kind of requirement that's implied and not expressed, and that is that the business associate agreement should be current and reflect the existing relationship between the covered entity and the business associate. So if your business associate agreement hasn't been reviewed in the last 12 months, or the relationship between the business associate and the covered entity has changed in a material way, or the services that the business associate has provided are changing in a material way, then the business associate agreement needs to be reviewed, and at least reviewed and potentially amended. So in addition to the explicit requirement to establish the permitted and required uses and disclosures, there's also an implied requirement that those established permitted and required uses and disclosures are accurate and current. And that's particularly concerning if a business associate started off performing one service and then evolved into providing more and more services, which may not be covered by the business associate agreement if it's not current. The second requirement is that the business associate agreement provides that a business associate will not use or further disclose the information other than as permitted or required by the agreement or by law. So this idea of least access necessary. Now, there is some good news from both the business associate and covered entity perspective. Covered entities are allowed to rely on business associates to support the least access necessary concept. So if there is a business associate agreement in place and the business associate requests access to additional information, the covered entity can rely on the business associate's position that the business associate needs that additional access as long as there is a BA agreement in place. The third requirement is that the agreement require BAs to implement appropriate safeguards to prevent unauthorized use or disclosure of information, including implementing requirements of the security rule with regard to electronic protected health information. So one of the ways to think about this for a covered entity, thinking, all right, what do we have to include to make sure that we have all of the safeguards necessary? And one of the ways to do that is just to think about what you as a covered entity have to, what kind of controls you have to implement under the security rule, and then pass all of those security rule requirements down into the business associate agreement. So things like risk management, appointing a security officer, conducting the necessary training for employees, policies and procedures, and all of the rest of the requirements under the security rule. The fourth requirement for business associate agreements is that the agreement require business associates to report to the covered entity any use or disclosure of protected health information that's not provided by contract, including incidents that constitute breach of unsecured protected health information. So some of the items that should be covered under this section include what circumstances would trigger this breach reporting to the covered entity. How do you define an incident? The second is establishing who is at the covered entity is the individual or group that should receive the notification of a potential breach. Third is what kind of information does the covered entity require the BA to report to it about a potential breach? And then making sure that a business associate has a policy and procedure in place for this. So beyond just the who, what, and the why, that there are actual specific, almost to the work instruction level of consideration, so that the BA has shown that it has anticipated what and knows what it would do in the event that an incident occurs. The fifth and the element and the final one on this slide is a disclosure requirement. That is, the business associate agreement must require the business associate to disclose protected health information to individuals who are requesting copies of their PHI and make their PHI available for amendment. So if a patient requests PHI and that PHI is held by a business associate, the business associate's systems and processes must allow for the patient to access that information if they're looking to just view it or if they're requesting any amendments. And then the business associate must, if it's required, be able to incorporate any of those amendments. And then finally, the business associate also has to account for those disclosures as well. So as we move to our next slide, we'll cover the remaining items that are required in a business associate agreement. The first item on this slide is that a business associate, to the extent it carries out a covered entity's obligations under the privacy rule, if there are any of those services provided to the covered entity, the business associate agreement has to require the business associate to comply with all the requirements under that obligation. So this is going to be one of those requirements that's going to be dependent on what kind of services a BA is providing to a covered entity. The next requirement is that a business associate must make available to the Department of Health and Human Services its internal records and practices and documentation relating to the use and disclosure of PHI. So not only does an entity, not only does a business associate have to be able to handle requests from a patient, a business associate also has to be able to handle requests and investigations from the Department of Health and Human Services. The third item on this slide, and our next to last item, is that if a business associate uses any subcontractors to provide services that are going to have access to protected health information, then the business associate agreement has to have a clause that requires those subcontractors to be subject to the same restrictions and conditions that apply to a business associate with respect to that PHI. So if the business associate is using subcontractors that do have access to PHI, anything that the BA has to do, the subcontractor has to do as well. The final requirement for a business associate agreement is composed of a couple of different parts related to termination of the relationship between the covered entity and the business associate. So the first is the BA agreement has to authorize termination of the contract by the covered entity if the business associate violates the material term of the contract. And the second component is the BA agreement has to require the business associate to return or destroy all protected health information. And so for the covered entity, either within the business associate agreement or in addition to the business associate agreement, two things that the covered entity needs to be thinking about are what is the standard for termination, what kind of acts or incidents would be considered a material violation of the contract. And then the second component is who makes the decision at the covered entity about when to terminate. And just as a side note, this termination, this idea about termination is something that's useful for any vendor agreement, not just for business associates and covered entities, but for any service provider. It's a best practice to make sure that you have all the all the necessary elements of termination in an agreement that consider what actually would require termination, what would happen upon termination, what happens to documents or information that are maintained or held by a service provider during termination, what kind of steps trigger termination, what kind of notice has to be provided. So this is something that's useful not just in terms of business associate compliance, but in any vendor management consideration. So now we've covered these 9 different elements for business associate agreements. I want to go to the second section of our presentation and talk about business associate oversight. And there are going to be 2 different parts to this section of our presentation. There's going to be the legal standards, and then there's going to be the practical considerations. So first, we're going to talk about the legal standards for business associates. And the first thing we have to acknowledge is that there is a weird dynamic with respect to business associate oversight under HIPAA. And I'll explain the weird dynamic in this way. Business associates are now directly subject to the Department of Health and Human Services for HIPAA compliance. So previously, only covered entities were subject to sanctions from the federal government, but now the federal government can come in and directly sanction and fine a business associate for HIPAA noncompliance. Additionally, HIPAA doesn't explicitly require covered entities to monitor business associates. So I know this doesn't exactly help the pitch that managing business associate compliance is important. But I believe we'll get there even though HIPAA doesn't explicitly require it, but it's important to understand that. And then third, HIPAA doesn't explicitly hold covered entities liable for business associate noncompliance. So at the beginning I talked about associated liability, and that's not directly or explicitly coming from HIPAA. What does happen though is the privacy rule creates an obligation on covered entities to be aware of what their business associates are doing and respond to the issues that a covered entity discovers by either curing the issue or terminating the relationship with a non-compliant business associate. So even though there isn't an explicit monitoring requirement under HIPAA, we get to the same kind of obligations because of the privacy rule. And so there are basically 3 different obligations. And I want to read out what the standard is and then explain those 3 different elements. So a covered entity is not in compliance with the privacy rule if the covered entity knew of a pattern of activity or practice of the business associate that constituted a material breach or violation of the business associate agreement. So that's one part. Yeah, the covered entity has to have knowledge of what's going on with a business associate, and not just knowledge of an incident, but of a pattern of activity or a practice, so ongoing or systemic issues. Secondly, if the covered entity knew of that, unless the covered entity took reasonable steps to cure the breach or end the violation, and if those steps were unsuccessful, terminated the contract if possible. So once a covered entity knows about a pattern of activity or practice that's non-compliant, the next step to maintain compliance with the privacy rule for a covered entity is to take some steps to either fix the issue or to terminate the relationship. So there's the knowledge of the pattern or practice, there is the remediation, and then there is the termination. So those are the actual regulatory obligations based on the privacy rule. So what does this mean from as we think about it from a practical perspective? A covered entity won't violate the privacy rule just because of a one-time failure of a business associate. The questions are, did the covered entity know about the issue and then try to cure it? And if curing failed, did the covered entity in a timely fashion terminate the business associate agreement? And what that ultimately means is that you come up with ongoing monitoring, because the best way by a covered entity of a business associate, because the best way to take the required steps to address patterns and practices is to check for those patterns and practices on a continual basis. So now we understand this weird dynamic of the legal obligation to evaluate for a covered entity to evaluate what a business associate is doing. Let's talk about some of those practical considerations. So first, how do you evaluate a business associate in such a way as to get the necessary information that would allow you to discover a pattern or practice? As I mentioned before, let's start with the positive. While having a business associate agreement isn't enough to show that a covered entity is complying with the privacy rule requirements, it does have its benefits. You do get to rely on a business associate to support that least access necessary requirement. So if you do have a BA agreement in place and the BA requests additional information, the covered entity can rely on the BA's position that it needs that additional information to maintain compliance. But that only gets us to a little bit of what's needed for oversight. The more challenging tool for business associate evaluation are audit and inspection rights. So we went through the 9 elements that are required in a business associate agreement, and you'll notice that you may have noticed that audit and inspection rights aren't required as an element. So not only are they not required, they don't even spell out the details of how audit and inspection rights should be exercised and who might pay for the associated costs with those audits and inspections. So there are at least 3 approaches that I can think of to audit and inspection rights as a way for covered entities to manage business associate compliance. And we're going to go through those 3 in the next few minutes. The first is a direct inspection and audit by a covered entity. The second is a third-party inspection or audit. And then the third is what I would term the just copy us approach. And I'll explain that a little bit later on. So let's first talk about the direct covered entity inspection, where the business associate agreement or just sometimes these audit and inspection rights are maintained outside of the business associate agreement. Sometimes they're not explicitly stated at all. They're just assumed, and the business associate agrees based on the business relationship. So those audit and inspection rights range from covered entities wanting to directly inspect training records and processes and subcontractor agreements to covered entities asking for almost nothing. This approach is becoming more and more of a challenge as covered entities are aware of their responsibility for looking for those patterns or practices, but also as business associates push back. There are some business associates that are saying, we're not going to show you our policies and procedures. In the past, this direct covered entity inspection and audit approach was not uncommon for it to be done through like a data security questionnaire. But those are decreasing in popularity because covered entities don't have enough resources to evaluate that questionnaire. So if a covered entity issues a spreadsheet with 300 questions on it, they get it back, and then they're telling us that they don't have enough time to go through and evaluate those 300 answers to determine whether or not the BA is doing what the covered entity wants. And as I mentioned, BAs are pushing back against broad inspection rights because business associates don't want to deal with dozens or hundreds of different questionnaires. It's time-consuming, they're inconsistent, and as I mentioned, sometimes they just don't want to share their policies and procedures and other reports with a covered entity. And they're getting to the point where they're saying, as a business associate, we'll do business with you, covered entity, but you just have to know we're not giving you any documentation. So as covered entities find that they have more and more business associates to monitor, and as they find that those data security questionnaires are less and less useful and they don't have enough resources, and as BAs are pushing back against direct covered entity inspection, the second approach that's becoming a little bit more popular is for a third party like Kirkpatrick Price to provide an evaluation. And the most common third party report for covered entities to receive or request is a SOC 2. And what may be becoming more and more popular is the option for the high trust common security framework insert into a SOC 2 report. So, so you get HIPAA considerations in a defined industry understood format. It's a third party having access to the policies and procedures. The business associate can have one SOC 2 report done and give the results to all of the covered entities, so you're not dealing with dozens or hundreds of different spreadsheets and questionnaires, and you've got something that's understood by the industry. But it's not all rainbows and unicorns with this third-party evaluation perspective. There are some issues that business associates and covered entities need to think about. So even though business associates might give a little bit more access or a lot more access to a third party than to their own covered entities, you still have the challenge of defining and deciding what kind of access that third party auditor or consultant or provider is going to evaluate the business associate is going to have. A second issue is who's going to pick or choose that third party auditor or consultant. Does the covered entity get to pick? Does the business associate get to pick? Do they work through some agreement where they create a list and then narrow it down to 3 and go from there? But who gets to pick the assessor for that kind of engagement? A third issue is who pays for the costs of a third-party audit. Some of these third-party audits can be quite expensive, and so is that a requirement? Is that a burden borne by the business associate, or does the covered entity have to pay for it? And then the final issue, for at least our consideration, is what kind of information does the covered entity get at the end of this whole process? Do they get the entire SOC 2 report, or whatever, some kind of custom or more standard HIPAA compliance audit report, or do they just get a summary of the report? And there can be some challenges in negotiating what kind of information a covered entity gets at the end. So as I said, there are 3 kinds of audit inspection approaches. One is for the covered entity to do it itself. The kind we just talked about is where a third party does it. And then the third is what I called the just copy us approach. So another option to certain audit rights is for the covered entity to tell the business associate, here are our security standards, and you have to meet these standards or we won't do business with you. So that's kind of a different option where the business associate doesn't have to provide a bunch of policies and procedures to the covered entity. There isn't a security questionnaire. There isn't a third-party auditor. But this just copy us approach has its own challenges. The covered entity has to decide how they're going to evaluate whether or not the business associate is meeting the covered entity standards. So in some ways, you're almost back to square one in terms of direct oversight. So what are some of the takeaways from this section? As it's been said to several times by those in the industry, vetting on the front end is more important than contractual inspection rights because of the pushback from business associates on inspection rights and because of the limited resources for covered entities to conduct ongoing monitoring and evaluation. It's really important to do business associate vetting on the front end. And then the second takeaway is that third-party audits are satisfying this vetting process. So, like I said, the SOC 2, including SOC 2 with the high trust insert, is becoming more and more popular as a way for business associates and covered entities to come to a joint satisfactory way of evaluating a business associate's compliance. So now we've talked about some of the challenges with business associate oversight and some tools and some approaches. Let's wrap up with some common issues that are involved with business associate oversight. So the first of those is the actual security measures that a business associate has in place for its HIPAA compliance. So for example, a hosting provider. Well, I pointed out the positive of relying on a business associate to request access to additional information. That's the limitation of relying on a business associate agreement for compliance. So one of the challenges is identifying what are the actual controls that a business associate has in place to secure information. The second common issue, it relates to mobile devices. Does the business associate allow laptops and other removable storage media? And are those laptops personal devices? Are those tablets personal devices? Are those phones personal devices? Are they all company devices? Is encryption used on laptops and other removable storage media and tablets and phones? And does the business associate have remote wipe capabilities for mobile devices, for example, if a laptop or a phone is stolen or lost? And the reason this issue is so important is because by far the most common cause of a PHI security issue is the loss or theft of a mobile device. So see, these are some of the important questions that a covered entity should be asking a business associate, and a business associate should be thinking about for itself in terms of mobile devices. Are you going to allow them? Will you allow personal devices? Will you require encryption? And will you have remote wipe capabilities for those devices? The third common issue is the issue of audit logs. It's important for covered entities and for business associates to maintain compliance with accounting for disclosures. And so one of the questions that a covered entity should be asking its business associates is, do you have audit logs, and do you review them, and can we have access to them? And a business associate needs to be thinking about whether or not it has the capability of keeping audit logs and to making sure those audit logs are tamper-proof and can't be edited. And then the last of these common issues is just the concept of business associate sophistication. So for all of these issues that we talked about, risk and oversight can and likely will be adjusted based on the business associate sophistication, based on the services that it provides to the covered entity, and because no covered entity has unlimited resources to monitor all business associates perfectly and equally. So based on the kind of risk that a business associate poses, a covered entity can rank and tier its monitoring and oversight efforts to ensure that its efforts are going towards the most vulnerable areas. So that concludes the three main components of our presentation today. And just to kind of wrap up what we talked about, the significance of business associate issues is already in existence, and it's growing. Half of all security incidents stem from a BA or experienced by a BA. There is ongoing and future regulatory activity that will impact business associate compliance. There are market forces, and then there are just the sheer number of business associates that are serving covered entities. And those should all be reason enough for us to be aware of and active towards business associate compliance. The second issue is we talked about the required elements of business associate agreements. And within that that section, we talked about the approaches to a business associate. Do you go the conservative, better safe than sorry route, or do you try to limit your oversight and exposure by only signing agreements with all of those required elements with entities that you actually believe are an existing and current business associate? And then finally, the dynamics of business associate oversight. Industry experience indicates that risk for business associates is greater with business associates that are actually smaller. Generally, those smaller BAs have fewer compliance resources. Also, risk is typically greater with newer business associates. It's a young company that may lack the general experience and expertise needed to be compliant with HIPAA, or they may have the expertise, but it's not yet fully implemented as other business needs take priority over HIPAA compliance. And then there are business associates that aren't generally in the healthcare sector that are still subject to business associate oversight, such as financial organizations, non-healthcare related software companies, and even, depending on how averse you are to risk, landscapers. And then you've got the challenge between what kind of approach to audits and inspections will you take? Will you take the approach where, as a covered entity, you're going to do all of it yourself? Or are you receiving pushback and you have limited resources, so you're going to take the approach where you involve a third party, but then you have all the considerations with respect to costs and reports and access? Or are you going to require business associates just to copy your standards and your controls? And then if you do, how will you evaluate that? So I hope that we've raised some of the key issues to consider when you're addressing business associate compliance, as well as giving you some tools for addressing those issues. So now we have a few minutes, and I believe we're going to open it up for questions.
Just a reminder, if you have any questions, you can submit those using the Q&A feature. Haven't seen any come through yet. Just wanted to remind everyone that attendees will be receiving a copy of the slides and a link to the recording, as well as their continuing education credit certificates. Mark, did you have any other questions that you wanted to specifically address during today's presentation?
No, if there are none from our participants, I believe that will conclude our presentation. Okay.
What you see up on the screen now is the calendar of our Road to HIPAA Compliance series thus far. You see all the topics we've covered. All of these pre-recorded sessions are available on our website. Our next session will be on training the workforce, and that will be sometime next month in August. So be on the lookout for those invitations to come through. And if you do have any further questions about managing business associate compliance or any other questions related to your HIPAA compliance, there's Mark's contact information there on the screen. He will be happy to answer any questions that you might have. So thank you again, Mark, for presenting today, and thank you everyone for joining us.